Hello, everybody. Welcome back to another episode of the Your Gray Matters podcast. I'm Jason, along here with my dad, Neil. Hey, Dad, how you doing today?
Doing really, really good. Thanks. Hi, everybody. Welcome back to the show.
And what a treat for everyone today. We have a lawyer on, and you don't have to pay for his time. Although you can by hitting the subscribe button below and by leaving a comment. That would be an excellent fee, I think. Why did we have this lawyer on?
In the last few years, I've had the experience, unfortunately, of going through a car accident, and a very close friend of mine had a very serious slip and fall. In both cases, there were injuries, but they seemed to be healing. We weren't sure, though, whether we should consult a lawyer or not because the damage wasn't pleasant. You're going to want to watch this podcast because the information that this lawyer, Brian Simo, will give to you on the necessity and the time limits of reporting an accident or a slip and fall are crucial to how things may work out for you. Stay tuned. This one's amazing.
Yeah, I really found it eye-opening to learn about all the ins and outs of that. Excellent. So hopefully you find it eye-opening as well. And without any further ado, we're going to get you this week's episode of the Your Gray Matters podcast. Welcome to Your Gray Matters, the podcast that unveils the miracles already amongst us. Here, we believe that the human mind cannot be defeated. Tune in to discover the fascinating people with extraordinary stories, innovative products, and groundbreaking services. With your host, Neil Silvert, who's earned his gray hair and still has use of his gray matter.
Hi, everybody. I'm Neil from the Your Gray Matters podcast, and welcome back. We hope that you had a great week. We have an amazing topic for you today. And actually, unfortunately, my bride and I discovered this topic the wrong way, and that has to do with when you have a personal injury. But I wanted to reach out to one of the great lawyers, the great specialists in this area who I know, a wonderful gentleman named Brian Simo. Hey, Brian, welcome to the Your Gray Matters podcast.
Hi, Neil. Pleasure to be here.
Hey, everybody, let me tell you about Brian. He really is a terrific professional guy in this area. In fact, he's always had a professional and personal interest in this whole area of suffering from illness, personal injury. He has been helping people all along. He graduated from Queen's University in 2005 with an honors Bachelor of Science degree, specializing in life sciences. And with this background, Brian has an in-depth understanding of the nature of injury and illness and the rehabilitation process. During his time at Queen's, Brian volunteered and trained the campus emergency response team, which assists people who are or injured on campus. What a start, Brian. Prior to obtaining his law degree from Queen's in 2013, Brian had a successful career as an adjudicator, case manager for the WSIB, which is Workplace Safety and Insurance Board, and he administered thousands of benefits for thousands of injured workers. Brian's interest in law was developed during his time with WSIB, and I have to tell you that he's one of the great advocates for helping people in this area. Brian was born in Hamilton, raised in Hamilton, and I will tell you that he's with a great law firm called Ross and McBride. Brian, thanks for coming on to the Your Gray Matters podcast. We're really glad to have you here.
Thanks, Neil. Again, pleasure to be here. Thanks for the great intro. Don't know if I'm blushing or if I got a leftover sunburn from hiking last week. One of the two.
Well, if you don't blush enough, we'll make you redder. No, I'm just kidding. So, Brian, I got to say this to you. We met you, unfortunately, as I said, because Linda and I were involved in an accident years ago, and a recommendation was to call your firm. We did. And that, ladies and gentlemen, is how we met. Brian, the reason that I wanted to do this podcast today, everybody, is simply because when these things occur, it not only affects the person who's had the accident or the illness And today, as you know, with Your Gray Matters, we focus at elders, but this affects everybody in the family. Brian, wouldn't you agree when somebody has one of these traumatic situations, so many people are affected?
Absolutely. And, we see cases that go right from when a baby's born, sometimes even injuries that happen before they're born, up until people pass, and sometimes even acting for their estates after they've passed away. So it does run the gauntlet. It can affect anyone at any time, unfortunately. And that's the
Yeah.
sad reality.
Yeah, I guess it's tough. Boy, oh boy. And what are you seeing nowadays? What's the most common types of personal injuries that you're seeing, especially with elders?
Yeah, it's changed over the years. I've been doing this almost 20 years now, working in this area between my time at WSIB and then as a personal injury lawyer for the last decade and a bit. But what I notice is number one, people are working later in life, and that changes the nature of what we see in accident claims. It means they're more active later in life. They're out in society in a busy way, quite often driving, commuting. That increases risk of things like car accidents, falls, workplace injuries. I've had a significant increase in clients in the 60 plus age range who are suffering from workplace injuries in representation. We see it with LTD claims, long-term disability claims, people in the 60 plus age range, and the unique characteristics that are around those because it count at a certain point. So it has changed over the years as we see an increase in retirement age. It does really change the dynamic of what people deal with.
It's really interesting what you said. It never even occurred to me. And I'm one of those guys at 70 who's still working. And actually, a few different things that I do, including this wonderful podcast. But yeah, I guess if you're in the workforce more and you're active, then these things happen. And while you were talking, I was thinking about my old mom who's 92 now. She only gave up driving 2 years ago, which amazed me. But she was smart enough to say, I've had enough. But people are driving much longer too nowadays, I think, which has got to have an effect.
Absolutely. And you see just as the average age increases, as life expectancy goes up, people are driving later. And a lot of that's for good reasons. They're more active, they're healthier. All of that is great. But it does mean that, people can be in situations as they're older and have unique challenges around trying to recover from injuries, recover from illnesses. It's just different as you get older.
Yeah, it really is. I know I'm a little more careful when I'm on the stairs and running around like a kook. So, Brian, comes to your office. They're needing help. Can you talk to us a bit of what's the typical process that you'll go through with them in handling this kind of a case?
Yeah, it all depends on the type of case that we see. So I always look at cases kind of in two different buckets to oversimplify it a bit. There's the accident type cases, and then there's the more chronic injury type cases. So we're representing somebody because they're suffering from something over a period of time and they're trying to access a benefit that they're not getting, as opposed to there's been a sudden event and the event has led to injuries and potentially disability and struggle as a result. So I separate that a little different. In the injury case, which I think is more what you're asking, it all depends on the type of injury a person sustained and the type of accident. We have different insurance schemes for different types of accidents in Ontario, and a whole nother scheme for workplace accidents in Ontario. And when we get involved in a case often depends on what type of case we're dealing with. With car accidents, we can be involved right from hospital bedside days after the accident occurred, all the way up to a year after when a person has realized that they're not recovering and maybe they do need some assistance because their insurance company is starting to shut off certain avenues of compensation to get treatment. And whatnot. So it's quite a varied range. How we approach it will depend on level of contact. Most lawyers will tell you the sooner the better. There's good reasons for that.
I remember we came right to your office when this had happened. I think what you're saying is don't wait, react, do something, is what you're saying.
Yeah, absolutely. And the reason is that there's two things you want to make sure you do after an accident. Number one, you want to protect all your legal rights. A lot of accidents have very strict limitation periods where you only have so much time to actually put a party on notice. I'll give you a good example. For a municipality, if there's a slip and fall on ice and snow on a city sidewalk, I believe it's a 10-day, I think, notice period now that the city has to be placed on notice within 10 days of the incident occurring. That is a very, very quick time. Contact a lawyer, speak with a lawyer, get your information on file, and then get a letter out. Basically, electronically, it's sent immediately now, but it's quick. So you want to do things sooner rather than later. The other issue is that evidence goes stale. Human memory is valuable. We know that. We know that as time goes on, people's recollection of things fade. That happens to everybody. People forget to save pictures maybe they took. People forget the details of things. We want to preserve that evidence as quickly as possible, especially if there's going to be any kind of issue with fault or liability in an accident. That evidence has to be preserved. So the sooner you contact somebody and the sooner you get involved, usually the better off.
So, Brian, actually, what you're saying is so important. Ladies and gentlemen, it's true. A friend of mine fell in a theater last fall, getting towards Christmas. And she was very lucky that she contacted her lawyer right away. Unfortunately, she was injured because, Brian, I remember that there was a real limitation on the number of days that they had to notify the theater. And so timing really is a big issue, as you're saying. She learned it's lucky that she came in.
Absolutely. And I wouldn't want to discourage anyone. If someone believes they may be past one of those limitations or they Google it online and find out, oh, it's 60 days, I'm past that. There are often ways around that as well. Again, contact somebody as a lawyer will walk you through that, do their best to get you around any of those limitation periods. But it is better to start them sooner rather than later. The final reason is sometimes, especially with car accident cases, how your claim is initially set up by your insurance company can actually affect what type of benefits they may approve down the road. And you want to make sure that's done properly. And if you don't have any representation, sometimes, not always, but sometimes that can be swayed or made a certain way to really limit your entitlement.
Yeah, that makes sense. And also, Brian, I guess at an advanced stage, if a person's a bit older, it's got to affect or it could affect the assessment of damages in a personal injury case. So there again, I am I correct? Like timing would be important too, I guess.
It can, yeah. Now, that's a bit of a controversial topic, and lawyers debate that quite often. One of the big damages we look for in personal injury cases is what's called general damages for pain and suffering, which is exactly what it sounds like. It's compensation you were paid because of someone else's negligence or fault. You suffered from pain and suffering. There's a cap on it, cap's about $400,000. Most cases obviously are much below that. But the assessment of that, how much of that you get case, does age play a role? And it's a question that we debate all the time in mediations and in trials and hearings because there's two different schools of thought. One of them is, well, if it's a young person, they have to live with this for longer, so they should get paid. There's another school of thought, which is that any limitation at the end of your life is taking away your golden years and the ones that you were supposed to be able to enjoy retirement. So you see a little bit of tension in that, a little bit of back and forth in how general damages and suffering are assessed based on it. The other thing, obviously, affects is economic loss claim. So in most personal injury actions, the lawyer is trying to determine has this individual suffered from an economic loss income as a result of their injuries. With people who are post-retirement, that's usually not the case. But again, as I mentioned earlier, that's one of those things that's changing quite a bit now. It's a lot of people are working later or they're doing second careers or what I like to call, I don't know what the official term is, I call them retirement jobs, which is that they continue to work even though they're not doing their main job. They've moved into something different that continues to earn them some income as they're in their retirement. I think we're seeing a lot more of that these days.
Oh, yeah, for sure. There's no question. And I find it interesting, but disturbing, Brian, because of course, sometimes when we get older, we end up with cognitive impairments like dementia. I'm wondering, how does that affect this whole process if somebody has a personal injury case?
Yeah, it's the unfortunate reality that can affect people as they get older. Obviously, not everyone can. And we actually have quite a few, and I've represented quite a few people who do not have what we call legal capacity. And capacity
Hmm.
is assessed differently in a legal setting than it is for other things. there's a bunch of different standards. So, for example, there's a certain capacity that in order to be able to write a will or do a power of attorney, that's one of the highest. There's a certain capacity you need to get married. It's actually much lower. Like capacity to instruct and retain and instruct a lawyer, somewhere in the middle of those. But one of the things I have to do with my clients as a lawyer is determine on my own initially, does this individual have capacity to be retaining and instructing me? Or are they unable to understand what I'm saying and telling? It's not fatal to a case if a person does not have capacity. There are methods of having someone, usually them, and act as what we call a litigation guardian, like a guardian for anything. It's a guardian for the purpose of litigation. And we've done that quite a few times. We use the same process for minors. It's very similar.
Okay, so you have to have someone else step in who can understand and give guidance and comfort to the injured person.
So from our perspective as lawyers, the really important thing is we need, I always tell people, your lawyer doesn't drive the bus. You drive the bus. You're in charge. My job is to sit right beside you and help you navigate and tell you your options and tell you what I think is the best way forward and how to do that. But you make the decisions. So a litigation guard is a person who's actually making those decisions on behalf of the person who does not have capacity, because I can't make them as your lawyer. I need someone to instruct me based on my advice usually, but I do need someone to give me instruction.
Yes, and that of course makes sense. And like you said, there's different outcomes that can come to these kind of cases. There's different amounts of money involved, but whatever it is, sometimes there's a lot of medical tests that have to be done. But at the end of the day, you have to be able to guide, they have to be able to make decisions. And so the process is as best to its ability. What I think I'm hearing you say is it's protective of the person who's had the accident, but sometimes that protection can have a lot of different layers. And I guess you're like the quarterback with that.
Yeah, although I don't know if I throw the ball to use the metaphor. At the end of the day, I'm more like the offensive coordinator, I think, where
Okay.
I'm analyzing the plays, giving advice, telling the quarterback what I think they should do. But I actually need the other person to tell me this is what I'm going to do based on your advice. That's really more the lawyer's role. Now, the lawyer will do most of the doing. That's what you're hiring them for as well, but based on your instructions and the advice that they've given you to make those instructions.
I think that this is a very important point because I think sometimes, maybe this is only in my own head, Brian, but I think people at times don't understand the role of their lawyer and the guidelines and but at the same time the education that the lawyer has and the experience and I found with the lawyers that Linda and I had to deal with at your firm, they're great listeners. You have to be a great listener when you're a lawyer, and well, you need a lawyer to know what they're doing and be on their game. There is a sensitivity that I've also noticed from the lawyers that I've dealt with some of these unfortunate accidents and problems. Is that a good definition for a lawyer?
Yeah, it depends on the type of lawyer I think, but absolutely. As someone involved in this type of litigation, personal injury litigation, I always say there's two really important characteristics that person needs to have. Being a good listener is one of them. And by being a good listener, it means both an active listener. So you're not just sitting there nodding your head, but you're engaged in the conversation. You're probing gently where you need information, but empathetically doing that as well, because you're dealing with people, unfortunately. And I say this about lawyers in general. Many of us are involved with people at some of the worst times in their lives. People are injured, fired from jobs, going through family law and divorces. These are not fun times for individuals. These are tough times. These are difficult times. So having a significant amount of empathy for people and understanding for what people are going through is really important. So both listening is really important, but the other characteristics that lawyers need as well, litigation lawyers, is they need to be able to explain complex topics in a simple way. That's a really important skill. And I think it's one of the most misunderstood or maybe not prevalent skills out there. Lawyers have a tendency, because we get into the nitty gritty of the law, to overcomplicate things. Because to us, it's not that complicated. We do it every day. We use these acronyms, we understand these terms, but our clients don't. This isn't their world. They need it simplified, not because they're simple people, not at all, but simply because it's not the world they live in. So being able to understand that and meet people where they are and break down something that can be very, very complicated in a way that is much more simple that they understand is a really important skill that, if you ask me, is not taught enough in law schools and is not screened enough when we, are deciding who's going to law school, who's becoming a lawyer. You're an educator all the time as well. And that's an important character.
Yeah. And like I said, we found our experience was that the lawyers that we were dealing with were very good at that. We never ever were made to feel like, as you said, we're not smart enough to understand. Those are my words, not yours. But yeah, we found it very good that the patience for the patient, I have to remember I said that, is really, really important. I'm really curious, Brian, though, what happens if someone passes away before the case is resolved? Because that's got to have another effect on everything. So could you comment on that?
Absolutely. And I've had a number of cases where that's happened, sometimes as a result of maybe injuries or disability that was part of the case. Other times, due to other reasons, natural causes or something else that had nothing to do with the case. But a case doesn't end when a person passes away. Their estate basically becomes, if they wish, the inheritor of the case. And what you do, there's a technical term called an order to continue that is filed by the estate. And it allows a legal claim, a litigation claim, to continue in the aftermath of a person's passing on behalf of the estate. And usually the estate trustee, the executor, will step in and be the individual who's handling it for the benefit of the estate.
That is actually really interesting and significant, I believe, because things do happen, of course, but it doesn't mean that the whole process ends. That is fascinating. Now, some people have pre-existing conditions, especially in seniors. How might that impact a personal injury claim?
Yeah, and in fact, I would go so far as to say not just seniors, but almost everybody. I try to take this. It's such a nasty term that we use, and you see it in American politics for existing conditions for health coverage, and you see it in litigation here, pre-existing conditions. People think it's some issue. And I always say we all have that. We've all been to the doctor. Who has not had some sort of health condition? I mean, maybe there's a 21-year-old out there who's perfectly healthy, but on the Olympics right now. But the rest of us have had something happen in our lives. And that's particularly true when we deal with mental health cases. I always say there's no such thing as an individual who does not have some sort of prior mental health noise. I use the term because it's not necessarily diagnosis, but stressors and things they dealt with in life. There's no one who comes in any situation having no experience. It's just not a thing. So how do pre-existing conditions affect the claim? Well, it depends on the type of case, obviously, but if you're bringing forward a claim for injuries suffered in an accident, let's say a car accident, and let's say you're dealing with someone who's 70 years old, has had a number of maybe some orthopedic issues, some angina heart issues. What you're looking at when you're looking at damages in a case or injuries is you have to basically subtract out what they dealt with before from any assessment of damages. You have to be very careful that what you're not doing is eliminating aggravations to those conditions. Give you a good example of that. An individual may have had, dealt with this recently, actually, a knee replacement. And they had a full knee replaced at the age of 60, 62. That was done. And then they suffer a fall. They suffered a fall because they tripped on a bolt that was sticking around that shouldn't have been. The litigation gets brought against the property owner who shouldn't have had a bolt sticking out of concrete, as you can imagine. The argument was, and the case was about, aggravation to that knee. And it wasn't to say the knee was perfectly fine before. It wasn't. They'd had a knee replacement. It was about the worsening of it and the aggravation to that knee replacement as a result of it. So that's an important distinction. Right? Just because there's a pre-existing condition does not mean that there hasn't been an aggravation of that condition as a result.
Hmm. That's true. That makes sense, actually. I have to say, Brian, I'm amazed now, and I've been amazed by the detail that one actually goes through when this sort of unfortunate accident happens. I mean, what you just said now, we call it pre-existing conditions, but the knee replacement, how it affects things with the person. I have been always fascinated by the detail and the time that it took just to understand the person who's had the accident, to create that picture where they were, where they are now, and where they may be in the future. And I found that to be fascinating, how well the lawyers can do it. And sometimes you need the help of medical practitioners, but it's quite a process, isn't it, Brian? And you have to be aware that you might be, as a victim, you might be in this for the long haul. This might take some time.
Yeah, and the unfortunate reality to all that detail is that it can be a fairly intrusive process. If you suffered injuries in an accident as part of the litigation, your medical records are getting produced, not public necessarily, but within the context of the litigation to the other lawyer, to your lawyer. I've had the more of a joke with clients that at the end of the case, I'll know your medical history better than you do. And there's some truth to that. There's truth to that sometimes. I say, remember that colonoscopy you had 4 years ago? And they have no idea what I'm talking about. But I do because I just read about it. The process can be somewhat intrusive, but it is very detailed. The lawyers go through medical records with fine-tooth combs looking for, mentions of things in the past, where it's talked about in the future, how it's discussed, and how the doctors or your therapist or whatever practitioner is recording it. All of that's quite important. And so, you know, one of the things that we become kind of expert at as lawyers in this field is actually looking at medical records. I spend hours a day reviewing medical records. That's just part of the job. I have a bit of a background in it, which helps. But yeah, it's a very detailed process. Absolutely.
And of course, the idea is that we're trying to figure out the fair and equitable compensation, if there is such a thing. But I guess you're also looking at the long term effects of, let's say, a slip and fall on seniors. I think of, although it could be on anybody, the long term effects. So as you're trying to figure out compensation, how do the long term effects play into all this, and how do you even measure a long term effect?
Yeah. So one of the challenges, in particular with seniors, is the unfortunate reality. And I say this as a 42-year-old who now is taking longer to heal from things. As we get older, we heal slower. As we get older, we don't heal as well. And that's just a biological reality of life. And so what we see, particularly in cases involving our seniors, is injuries are more significant from less trauma, as you would expect, but also the healing process is delayed or leads to permanent injury where it may not in somebody younger. How do we measure that? Well, there's a few different ways. Often it's obvious on documents we have. So on their physiotherapy, it's their physician, their own evidence, they get to testify as well. Sometimes it's very clear. It's obvious. A person has a shattered elbow and that elbow or arm never really heals despite surgery and whatnot. It can be very clear. Other times it's more nuanced. And what we do in those times is we actually hire physicians within the context of a litigation. These are not your doctors. These are outside physicians that are brought in, experts we call them, and they do an assessment, a medical assessment of the individual and provide us with an expert opinion as to things like the diagnosis, prognosis, so what they expect it's going to be, the limitations that exist, any treatment recommendations that haven't been done yet. And the other side, the defense, gets to do the same thing. So they will bring in another doctor, they'll do their assessment, and they'll provide a report as well. And a lot of times, if cases go to trial or hearings, what often happens is you've got dueling experts. Cases is much about the dueling expert reports as it is bringing else.
Brian, do you find, is it a higher percentage that I don't even know if you can answer this, are more settled than go to court, or do a lot of people still end up in court? I don't know if you can make a general statement about.
Oh, easily, yes, yeah, much more resolved pre-trial before a trial than go to an actual court. Now, that's not always the case in all types of cases. So, if we're talking about car accidents, slip and falls, long-term disability, litigation, anything in a court a lawsuit's being filed for, the vast majority of them will settle before trial. There's a lot of reasons for that, which I can get into, but most will. However, a lot of cases now are being adjudicated through administrative tribunals. So, for example, WSIB claims, where I represent people who have a workplace injury, those will often go to a hearing, much more. It's a very rare they actually settle outside. They can, but they very rarely do. Things like your no-fault benefits that we help people with through car insurance, they're called statutory exit benefits. A lot more of those are going to hearings now, which too, although those can also settle before that. So it does depend a bit on the type of case, but the vast majority will resolve without trial.
And Brian, thank you for that. And I've learned that there's a need to manage expectations, especially when it comes to financial expectations. There's a big difference, and maybe I'm wrong, but there seems that there's a big difference in what can expect in the outcome financially. I'm talking about with a slip and fall, let's say, as opposed to a car accident. I think car accidents have more limitations on expectation of the financial outcome. Am I right, or could you tell us?
Yeah, you are. That's because there's different regulations and legislation around. So one of the things the Ontario government did many, many years ago, long before I became a lawyer, is they brought in something called the statutory threshold deductible for pain and suffering damage in a car accident. It's a lot of words. What it means is, in order to get any money in a car accident for pain and suffering damages, you have to have an impairment that is considered both serious and permanent. Permanent, we all know what that means. Even if it's there, it's not going to go away. Serious means, my way of explaining it is, it's interfering with an important aspect of your life. So, for example, it's causing you to work differently. It's causing you to parent differently. It's causing you to eliminate a bunch of pastimes. It has to be something important. That's the threshold, just to get money. And then once you get over that threshold, there's a deductible. Now, the deductible, and it's infinite wisdom, the Ontario Court of Appeal said, goes up with inflation now. So it started off at 30,000 years ago. It's lower than that previously, increased it to 30 legislatively. And now it's tied to inflation. So it goes up every year. It's up to around about $45,000 in 2024. And so to get any damage for pain and suffering, you have to have serious and permanent impairment and at least $45,000 worth of pain and suffering. Now, of course, that belies the question, what's $45,000 of pain and suffering? And that's a very nuanced thing as well. But it's not a
Well,
minor.
I was going to say, I was trying to figure that out.
Yeah, it's not minor aches and pains. So if you have a car accident and you're stiff for a few weeks, you need a bit of physiotherapy, you need some chiropractic massage therapy. And after a month or two, you're feeling a lot better and you're back to your normal activities. You probably do not have a pain and suffering case in Ontario for car accident.
Uh-huh. Uh-huh. You know, I find it fascinating what you're saying, Brian, because as we just said a few minutes ago, if you feel that something's wrong and you have a case, you should see a lawyer so that that person can help determine for you if you have a case. And if you do, is it worth the time and effort and expense? And I guess what you were just telling us plays a big part of that, because a long-term injury versus, you know, having an injury that clears up 2 or 3 days later, that's two very different things. And so it's important, I guess, for the lawyer to help decide whether it's even worth the whole process and the procedure. Brian, I'm curious about the changes that do go on. I mean, you just mentioned how inflation can play a role in all of this. Are there any recent legal developments or precedents that have significantly impacted personal injury cases for seniors?
Well, I don't know of anything that's groundbreaking that's come out recently. Case law is produced all the time. And so, that takes a deep dive to take a look into it. But what we have seen an increase in terms of litigation, we have seen a significant increase in litigation around things like nursing home negligence and other types of, I call it care negligence involving seniors. That's been a focus lately, quite a big focus in the personal injury litigation. And that's simply because the population of people at these facilities is significantly increasing, and we're starting to get some societal awareness of some of the concerns that arise, things that families have been aware of for a long time. But you're seeing more and more of it in the news. You're seeing more and more of it in legal papers and litigation as standards aren't being met, as people are suffering as a result, both in just general negligence to their well-being, but also in injuries they sustain because they're not being cared for properly. So there's been quite a bit of that. Right?
Wow, that's unfortunate, but people are living longer and they're older, and yeah, and you know what? It's hard enough to find a facility now to go into, and I find that people sometimes jump into these facilities not even fully cognizant of what might happen to their loved one once they're in. And I'm not saying that these are terrible facilities or places to go, but it's important to understand because you're not going to be there all the time and someone else is going to be watching over your loved one. And sometimes things do happen to people.
Yeah, and it's a difficult position for families to be in because they don't always have a lot of choice in where a person goes. That's part of it as well. I'm not an expert in the placement regime and how it works, but I know there's not always that much choice. The other issue, of course, is that people are afraid to rock the boat. They're afraid by complaining and making their terms making a stink. I don't think it's that, but trying to even advocate that they're going to make the situation worse. There's a real concern over that. So people are afraid to rock the boat sometimes, even though there are significant issues. And listen, there are care facilities who do wonderful jobs and people who are angels who work in these places. So I want to, I have family who does. So I know that. But I've also seen some horror stories and I have seen things in documents from these places that are falsified. I have seen things that are clear abuse on its face. I mean, it's horrific what sometimes can happen as well. You get both ends of the spectrum. So it's a really difficult position for people to be in. And people in that position are vulnerable. Right?
Yes, exactly. Brian, just so let's talk about the cost of this just as we get set to wrap up. And thank you, Brian, for this. Brian, when someone has an accident, I've noticed, especially with personal injury or automobile accident, you don't have to worry about can I afford the lawyer? There isn't there a different way of looking at this? Doesn't the lawyer get paid based on whether they win or they're unsuccessful? And I know with your firm, you can come in and discuss these things and be able to visit with the lawyer, not be afraid that you're going to get a massive bill just for discussing things. Talk to us about how the financial end works, because maybe that's of great interest to people, of course, but maybe it holds some people back.
For sure. First off, any lawyer that I know who works and specializes in this field will do an initial review of your case free of charge. I don't think I've ever charged a client. Someone correct me if I'm wrong. I don't think I've ever charged a client for an initial consult. I consider that part of my job. Part of my job is to determine whether a person has a case that I can help. They don't get charged for that. That's just me determining whether this makes sense to set up this relationship. And so most lawyers I know who work in this area will do the same. If a lawyer is asking you for a consult fee for a personal injury type case, I'd be a little skeptical. I might go somewhere because that person may not work in that field. But you're right in how lawyers are paid to do this type of work. It's not every case. I mean, there are cases that we do differently. Sure, the vast majority of our cases, the individual has been either in an accident or denied benefits or disability benefits or done disability benefits. This is not a person who can put down a $10,000 retainer for a lawyer to start working on their case. That's not the reality. And so for many, many years, lawyers in this field have worked with the approval of the Supreme Court who understands the importance of this stuff in law societies. They've worked on a word called contingency fee. And, to steal a bit of a quote, hopefully I'm not getting too bad of a job. It's not copyright, but, one of the things you'll see on TV is the famous, you don't get paid until you get someone's slow, sure. But that's the gist of a contingency fee agreement. But there are nuances to that people have to be aware of as well. So what that means is you're not paying the lawyer for legal fees unless they achieve a resolution for it. A resolution as defined by the agreement, usually a settlement or an outcome in a hearing or court. So they have achieved some sort of compensation. A percentage of that is their fee. That's the contingency, contingent on a successful outcome. HST is charged on that. But in most contingency fee agreements, and this is where it's not a totally risk-free venture, there are also something called disbursements. And that's an important thing that can become a big deal. Disbursements is money that your lawyer is spending, law firm is spending, on behalf of you to move your case along. So a good example would be requesting medical records from a hospital. Maybe it's $50 to get those. Requesting police records from a motor vehicle accident, it's another $50. Filing a statement of claim in court, I think that's around $200 now. Those things are all being incurred on your behalf. The firm is paying for it. You're not paying out of pocket. But the firm in most contingency fee agreements can still ask you to pay those, even if your case is unsuccessful, or if you decide to withdraw your claim for whatever reason. So there's an important difference, but it's not a totally risk-free venture because of that. However, that's all dealt with at the end. And in the vast, vast majority of cases, those are paid by the defendant as part of the settlement or the resulting trial.
Uh-huh. Okay. Okay. Thank you for explaining that. I think even I seem to remember that there's even an insurance policy one can get in correct me if I'm wrong, in case it doesn't go the way of the person who's had the accident or the illness, and they might have these disbursements, but isn't there some sort of insurance, or am I wrong that they can purchase to protect them for that?
Yeah, you're absolutely right. So that's a product that came in, apologies, about, well, we've been doing it for a while now, but I think about 5 to 10 years ago, it became a bigger, important thing in the Ontario legal marketplace. And what you can do is you can purchase what's called the general term for it is after the event insurance. So it's purchasing insurance on your litigation. And therefore, if your case fails, you don't get stuck with both a massive disbursement bill, so your lawyer, but also the other risk in cases is that if you went to trial and lost, the other side can claim a portion of their legal fees against you for forcing them to a trial. So it protects you in that case as well. And basically what it is, it's a small fee that gets stuck onto your case that should there be a settlement, it comes up with that.
Yeah, but it sounds like an important piece.
It can be, yeah. I'll say this, it isn't actually in every case necessary. If you have no assets and you have no ability for anyone to collect a judgment against you, what's the point of insuring yourself? I mean, you're insuring what? So we do an analysis of each client to determine whether it makes sense. But there are cases, especially if they're higher risk, that, yeah, you want to have some protection for yourself.
Yes. Well, Brian, I want to thank you for coming on today. The takeaway I'm getting is if something's happened to you, you feel injured or you've had an illness, it's worth contacting, I'm going to say Brian or your firm, because it pays to know. And I don't mean that as a joke. It pays to know. I mean, you need to know. You need to know if in fact you should be seeking the help of a lawyer, and it's best to ask. Brian, if people want to get a hold of you, what's the best way for them to do that?
Sure. Well, we have a number of ways. It's not difficult, but we have obviously a telephone number, 905-526-9800. That's our firm's general line. They'll get you through to myself or whoever's available. It may be you speak with another one of my colleagues, you speak with our clerk first and when a meeting or something, but we do our best to get you on the phone with a lawyer as soon as we can. Because that's support. You can also go on our website. We have all of our emails there as well. You'll see profiles of every lawyer at the firm. Their website's just www.rockmcbride, all one word, .com. And you can go and you can research who you want to speak with. Do it by department as well. We do obviously other things too. My department does personal litigation, but we have estates lawyers, family lawyers, commercial lawyers, business lawyers, real estate lawyers, you name it. We have someone who does it usually. But yeah, and there's also on the website a direct link to as well. A little box pops up. Say, question, would you like to speak with someone? Even put something in there and someone will get in touch with you. So whatever's easiest for you.
Well, Brian, I want to thank you so much. As I said, the takeaway is if you feel that something's happened or you know that it's happened, don't be afraid to reach out. There's a lot, I'm going to finish with this, and I mean it sincerely. There's a lot of, jokes and comments about lawyers and silly things that people say. But I have to tell you, the lawyers that I've engaged with have been good feeling people, highly educated, very interested in the success of their client. And I have never been made to feel uncomfortable with a lawyer. And just want to thank you so much for coming on today. Ladies and gentlemen, please take care of yourself. Reach out to professionals if you've had an accident, if you've had an injury, if you have an illness. Don't be afraid to reach out to professionals. That's why we have them. Brian, thanks so much for coming on to the Your Gray Matters podcast.
My absolute pleasure. Yeah, thanks for having me.
All right, take care. Bye, everybody. We'll see you next Monday. Thanks for watching. If you found it interesting and you liked it, give us a thumbs up. If you're ready to subscribe, click right here. And if you'd like to see another episode, click right here. Tell a friend. Send us comments. Thanks a lot.